Okay, sorry for the delay. We're up on the YouTube channel as well. So we've got a 9:30 calendar. It's labeled a final plea calendar, but we're going to do a little more than just some final pleas. Our first position on the calendar is Glenn Goolsby, who is available here in court, and his lawyer, Mr. Franklin, just walked in. Good morning, Mr. Franklin.
Good morning. I apologize. I was in the call talking to another client.
Not a problem. We're having technical issues on my end solely, and so we are just now standing things up. Are you ready to have Mr. Goolsby come out?
Yes.
Great. Mr. Pinion, are you ready to talk about Mr. Goolsby's case?
Yes, Your Honor.
Great. Let's bring out Mr. Goolsby. Will do. Ms. Snyder, Mr. Thompson is coming in.
With everything that happened last week, they haven't moved all our stuff yet, so I don't have any of my files.
Okay.
We're supposed to have access to the new building next week.
Where is the new building?
Well, I thought it was self-employed, but apparently it's the old Court of Appeals building.
Okay, so you guys were in the State Bar building and you're going to the old Court of Appeals building.
They told us it was self-employed, and then all of a sudden we were moving. The new address was 270 Washington Street.
All right. Well, it's even closer to the courthouse.
But I still haven't received the state expert report.
Okay, we'll work through it. I just was curious if he was going to be here.
I don't have a phone number for him.
Mr. Goolsby, if you would take a seat, please, the seat with the microphone, that would be great. All right, good morning, Mr. Goolsby.
Good morning, John.
Mr. Franklin, today is the final plea date for Mr. Goolsby. Given the charges he faces, it's not a meaningful event as in other cases, but tell me what we're doing in his case right now.
We're maintaining our plea of not guilty. As I understand, the state's offer is life plus 5. That's something we're willing to accept.
Let's just confirm that. Mr. Pinion, as I understand it from Mr. Franklin, the state's offer, if Mr. Goolsby wanted to plead to all the charges in the indictment, the state would be recommending a sentence of life plus 5. Is that correct?
Yes, Your Honor.
Okay. Well, it's the statutory minimum. It looks like, I guess the 5 is negotiable as to whether it's to serve or not. Mr. Goolsby, you're not interested at this time in entering a plea to a sentence of life?
No.
Okay, I understand that. I believe I have ruled on the outstanding evidentiary motions. There may be pretrial motions in limine, things like that, but I ruled on the 404B as well as the motion to suppress ID. So I think this is a case that can go onto a trial calendar such that when you're ready, Mr. Franklin, to push forward and we can get jurors in here, it ought to be one we can tee up. Is that a fair statement?
Yeah, I spoke to Mr. Goolsby about it yesterday, and essentially whenever we're able to kind of start, I would anticipate this. I have about 3 that are like, I'm sure they would be first out.
Okay.
Amongst themselves. So.
The way, just so Mr. Goolsby knows that I'll probably prioritize them unless there's some logistical issue, is whoever's been sitting in jail the longest. You've been in jail for a long time. You are high up on that list.
Yes, sir.
Sadly, there are a few folks who've been in jail even longer. So when the lawyers are ready to come back into court and we can get jurors safely into court, this will certainly be near the top of that list. You and Mr. Franklin should talk about that as to when he feels like it's a good time to make that happen once we get jurors in here. But that's all that's left, is to get you your jury, and the state will see if it can prove its case. Mr. Pinion, anything else in Mr. Goolsby's case from the state?
No, Your Honor.
I have heard that maybe your successor here has been identified. Have you heard that, or do I get info you don't get?
You have info I don't have.
Okay, well then I'll just keep that name to myself and we'll see what happens. But I appreciate you plugging in for this one. Mr. Franklin, anything else for Mr. Goolsby?
No, sir. I need to print something up and get him a copy before he leaves today.
Okay.
Nothing else I need to discuss.
All right, so if you all don't mind keeping Mr. Goolsby up, we'll get Mr. Franklin a chance. If you need to send it to Ms. Nelson, it can print out here or whatever you need.
I just need to put up a copy of the order. So of
The order,
of the ruling from the hearing.
okay, should I just do that now?
Yeah.
Okay. It was two different orders?
Okay.
You want both?
Yes.
Okay, all right. I'll do those, and we'll pivot to the next, case. All right, Mr. Goolsby, so next stop, we got to get you a jury, and Mr. Franklin will keep you posted. All right. So the next case is a co-defendant case. Mr. Thompson and Mr. Norris. I see Mr. Shepard, so we've got him online. And Mr. Norris is here, Mr. Shepard, so we can have him brought out in a moment. Do we have an update on Mr. Thompson's whereabouts?
The only number that I have for him is one that he had at the time of the incident. It has since changed. It's in my file. And I just don't have access to my file.
What's your best guess as to when you'll have access to your file?
It was last night that we should be allowed in the new building.
Okay.
At some point next.
All right.
He's usually really good about staying in contact with me and showing up to court. He's never been to court.
Well, this is a notice calendar, so he would have had something mailed to him to be here. Well, let's talk about Mr. Norris's situation, and then we'll circle back as to whether we'll have a bench warrant ready for Mr. Thompson. These are pretty serious charges for him to be rattling around and not coming to court. But I also understand you can't call him because you don't have his number.
It's been a whole.
It sounds like it's been a pleasant experience. It's not like you have work you need to get done. Okay. Mr. Shepard, you ready if we bring Mr. Norris out?
Yes, Your Honor.
Great. Good morning, Ms. Hall. Are you ready to talk about Mr. Norris's case?
Good morning, Your Honor. Yes, I am.
Great. Hey, Mr. Norris, if you would, why don't you come on up to the podium? That'll be the best option for you. So, Mr. Norris, I'm Judge McBurney. You should see your lawyer on the screen, Mr. Shepard. There are a bunch of, is the screen not on right there?
Yeah, that's not my lawyer.
The guy waving?
Yeah, that's not my lawyer. My lawyer is Christopher Toll.
Well,
Your
let's
Honor, if
look
I
at
may
it.
clarify, can I clarify for the court?
Hold on 1 second, Mr. Shepard. Just letting the printer quiet down. All right, let's get back to Mr. Norris. So Mr. Norris, you've got a couple cases here, an armed robbery case where you've got a co-defendant, and then one where you're charged with attempted armed robbery, no co-defendant. And I've got on my records that Mr. Shepard is your lawyer.
I tried to fire him several times because I had got Christopher Toles on all my cases. Christopher Toles is on my cases now.
Okay, you or someone, a friend or family member has paid Mr. Toles?
Yes, he's paying $30,000.
Okay. Because I'm not seeing in the docket. I'll let Mr. Shepard give me an update from his side. He's in
Mr. Norris has a third case.
Oh,
20 CP 194161, in which he's charged with murder. I spoke with Chris Toles yesterday, and I spoke with Mr. Norris's mother this morning, both of whom said that Mr. Toles has only been hired to represent Mr. Norris as to the murder case 20 CP 194161. Chris Toles has entered an appearance on that case, and I have withdrawn from that case. However, at this time, the information I'm getting is that they have not hired him for either of the two cases on your calendar. And I, as his appointed counsel, I can't just dip off.
no, you can't. Exactly. I wouldn't let you. But nor are you trying to. So that's helpful information in a couple ways. It sounds like, even though I thought these were your two serious cases, you've got an even more serious charge hanging over your head right now, Mr. Norris. And Mr. Toles is your lawyer there. We're gonna take this one step at a time. So you've got an unindicted murder. Chris Toles represents you. No question about that. You've got, I'm gonna call them armed robberies. I know one of them is an attempted armed robbery, but you've got two armed robbery cases here with me. And right now, legally, your lawyer is Mr. Shepard. You can just let me finish and then, yes, I promise I'll hear from you. Mr. Shepard is relaying to me that he spoke with your mother and with Mr. Toles. Both of them are saying, no, Toles only has the murder. So you're saying something different. They're your cases. They're not your mom's cases. Tell me why you think Mr. Toles represents you on all three.
Because Mr. Toles was aware that I was for this, and I was ready to get this over with. I was going to plead first offender because I never been arrested. Had felonies in these orders. I never had these type of felonies. So Toles told me that's what he was pleading for me today. So I'm kind of confused myself, but that's what he told me he was going in for today to give me my first offender probation. But
so Toles told you he'd be here today?
Yes, he told me this. So I'm confused myself.
Okay. Well, I'm super confused now because I suspect, although I'll hear from Ms. Hall, the prosecutor, in a minute, that no one was going to offer you probation or even first offender for armed robbery. But I don't know a lot about this case, and it may be that the state was going to dismiss or reduce a whole lot of things. Ms. Hall, have you ever spoken with Mr. Toles in connection with Mr. Norris's two armed robbery cases?
I have not, Your Honor.
Okay. Was there an offer ever made to Mr. Shepard on behalf of Mr. Norris that would resolve Mr. Norris's armed robbery cases as a first offender with probation?
No, it was not.
Okay. So it sounds like, Mr. Norris, you and Mr. Toles need to connect again. Mr. Shepard is not going to be relieved from responsibility for representing you in the armed robbery cases unless and until you say you're going to represent yourself. Bad idea. Or Mr. Toles files an entry of appearance. He can do that. If he files something that says, look, I am now Mr. Norris's lawyer, then Mr. Shepard responsibly can say, I'm stepping out. But he's been appointed to represent you, and he can't walk away from it unless you say you want to represent yourself, which I don't think you want to do, or some other lawyer steps in saying, no, I've got this one.
No, I actually do want to give Mr. Shepard a chance. I was confused too. I did not know. I thought Toles was on all my cases.
Okay, got it. So you're okay with Mr. Shepard and the work he's done on the armed robbery?
Never done no bad. He never done nothing bad to me.
Okay, great. Well, that's good to hear. I'm glad he hasn't done anything bad to you. then let's have the conversation we need to have about the 2 armed robbery cases. And then, they may be on hold anyway because of this other case that's rattling around out there that you have with, Mr. Tolles. So, Ms. Hall, if Mr. Norris were inclined to resolve his 2 cases today, his indicted cases, what is it that the state would be recommending?
On the 316 case, the offer was 20, serve 15. That's on the armed robbery. And the 927 case, it was 10 serve, 10 to serve, I'm sorry.
Okay, to run concurrently with the other?
Yes, Your Honor.
Okay, all right. And Mr. Shepherd, those are figures you've heard before?
No, that's the first time I've heard these offers.
Okay. Well, it sounds like we need to reset this anyway because we don't have Mr. Thompson. And Mr. Thompson's lawyer is locked out of her office through no fault of her own for a few more days. And Mr. Shepherd, you and Mr. Norris ought to have an opportunity to discuss the state's offer. If you are hearing this just now, then you haven't had a chance to tell Mr. Norris that that seems reasonable or it's not reasonable or wherever you may fall on this. And then, of course, there's the wild card in the mix that there's an unindicted murder that Mr. Norris is going to need to address at some point with a different attorney.
If I can add something to this.
Please.
We were able to get the discovery for 316, which is the armed robbery case from the public defender office, Ms. Patel. And she also provided us everything and that appeared to be mostly complete. And we were able to file motion to suppress everything we need to on 316. So we're pretty much ready to go on 316. The discovery that was provided to our office by Ms. Patel on 927 is only the 911 and the cab, which doesn't give me enough information to get ready for trial. So we're missing a huge chunk of discovery as to 927. And we have previously filed two motions to compel that discovery and still have not received it. So we're not ready to move forward on anything as to 927 without substantive discovery. So we would need to do that before the next final plea day.
So on 316, you mentioned something about a motion to suppress. Was that argued and ruled on, or is that out there and we need to have a hearing?
I was just appointed in October, so it's out there.
Okay.
And then obviously we need the complete discovery for 927.
Of course. All right, let me look at something. And Mr. Norris, I promise I'll ask you if you have any questions about all this as well, because we've been talking about a lot of stuff.
Is it okay for me to talk to my lawyer? Is it okay if I say anything?
Oh, you can say something. Just don't say something you wouldn't want. The prosecutor can hear you. So if you were going to say, hey, you know what? Remember where I told you about this secret thing? I wouldn't say that right now, but you got a question.
Well, I would just say there's really nothing for us to talk about right now because we can't plea you guilty to an armed robbery and an attempted armed robbery with the potential for a murder trial down the road, because then the state could use that against you.
So, and more profoundly, I see now in the docket, there is a motion to suppress statements that you filed, Mr. Shepherd, as well as a motion to suppress identifications. And you, as Mr. Norris's lawyer, and Mr. Norris, as the person who would be entering the plea, need to know, is that kind of evidence coming in at trial or not? It makes the state's case much stronger if there were identifications made and they're coming in. And I don't know what kind of statements you contend that Mr. Norris made to law enforcement, but if they were not helpful to him and they're coming in, then that's another reason why pleading the case out may make more sense to Mr. Norris. So we need to have hearings on those two motions.
I think there's a motion to suppress evidence too.
There could be more. I was at the summary screen. Let's see. Yes, 3 motions. Look at that. Boy, you've really papered up this file. So we need to set those 3 down for a hearing date. So that Ms. Hall has a chance to get witnesses here, et cetera. Mr. Shepherd, you can see we're able to get Mr. Norris into court. Assuming we can get all of the state's witnesses into court, are you making in-person appearances, or how are you managing if we do get a date that works for your schedule and Ms. Hall's for an evidentiary hearing?
I'm appearing for all substantive events. For events that are procedural in nature, I am not appearing. If I felt if there was a possibility that this case was resolved by plea today, I would have been there in person. But given Mr. Norris's unique situation, it would not be advisable for him to plead today under any circumstances. So that's
No, I agree. And that's not, we're going to reset the final plea. This is helpful to figure out where we are. Ms. Hall, I guess what I'm going to have Ms. Nelson do is get with you and Mr. Shepherd about setting a hearing date for the motions in 316. But before we do that, I guess it makes sense for you to try to get the discovery in 927 to Mr. Shepherd, because if he's going to file motions in that as well, we may just have a Norris day where all we do is work through motions in those 2 cases. Do you have a sense as to how extensive the discovery is in 927?
No, it consists of digital. So that was something, I'm not sure why Mr. Shepherd hasn't received it. That was sent out by my admin back in November for both cases. And then I was aware that Ms. Patel did give everything over in November as well. So I'll just get back with my admin and make sure she resends that out to Mr. Shepherd. But no, it's the normal, the body cam digital.
But you think it's all in one place, that there weren't things you were still trying to get. You felt like you had the discovery for 927.
Correct.
Okay. Then why don't we give you want a week to get it to him? How much time how much time do you need?
A week should be fine. I just need to get with my admin. I know that they were working this week. I'm not sure if that will be remote next week or not, but I'll get with her today so that anything that she needs, she can get it from the office this week.
Okay. So we'll say discovery to Mr. Shepherd within a week. Mr. Shepherd, how much time would you want to go through the discovery in 927 to see if you have any particularized motions you want to file?
Well, we're a little backed up right now, so I would just ask for 20 days, 30 days to go through it all and get the motions filed.
Okay. Maybe what I'll do is set out a month from now. So end of February, last business day of February is February 26th. So we'll say March 1. By March 1, you should either, Mr. Shepherd, let Ms. Nelson know I still don't have discovery, or the disk doesn't work, those kind of issues, or have filed any particularized motions in Mr. Norris's 927 case. If we don't receive anything by March 1, we'll know that the only things we need to calendar are the 3 motions from 316, which we'll try to do in mid to late March to give the state a chance to subpoena witnesses, et cetera. We'll get Mr. Norris in here, you in here, and the witnesses in here to litigate the 3 motions in 316. Is that a time frame that works for you, Mr. Shepherd?
Yes, if I can get the discovery from the state within a week to 10 days, yes, I can be ready to file everything I need by March 1.
Great. And if you don't need to file anything, that's fine. It may be that there aren't particularized motions in 927. There certainly are in 316. But we won't calendar that till we know the answer in 927, so that we don't need to keep bringing you and Mr. Norris back in here. We can try to handle it all in one setting.
And
then, yes, ma'am.
If I may interrupt, Ms. Patel just reminded me, if Mr. Shepherd can go through the disk that he has for 316, I forgot that these incidents happened on the same day. So the body cams are on the same, the evidence is on the same body cam. So if he has the body cam for 316, he should also have it for 927. But once he looks, just let me know, because they kind of loop both of these cases together.
Okay, so it may be that in getting from Ms. Patel what he thought was just 316 and a 911 call from the cab, he actually has everything from 316. I'm going to leave it to the two of you, Ms. Hall and Mr. Shepard. You work fine together, and I know you'll get Mr. Shepard another set if you need to. If we set a March 1 deadline, I think that's enough time for Mr. Shepard to sort through all that. But that's very helpful. I think Mr. Shepard, get the discs again or thumb drive, whatever it's on. 927 may be tucked away in there with 316.
Well, we printed every piece of paper on all the discs, and there's no police report. There's no things of that nature for the 927 case. There may be body cam, but it's hard for me to formulate motions from body cam.
Okay, there's nothing to put it into context. Well, again, I'm going to ask Ms. Hall to just check what she's got and confer with you. And we'll have that March 1 deadline for particularized motions in 927. And then we'll set a motions date for mid to late March to hear these motions and get closure so that we can actually have a final plea hearing to see if Mr. Norris is going to be working out these armed robbery cases. In the meantime, I would hope that the state will figure out what it's going to do with the unindicted case, because if that does get indicted, it's coming here, and that would likely sideline these two cases because we'd focus on the murder case instead. All right. So, Mr. Norris, we spoke a whole lot. You were very patient and listened. Do you have any questions?
Yes, what you mean by sideline? The cases will be sidelined. Can you explain that to me a little
Sure, and that's not a legal term. Here's how it will work. If, and I don't know what the state's going to do, they have not indicted you for the murder, the grand jury hasn't, but if a grand jury will be back in action as of March 1 or 2, sometime in early March, the state may seek to indict you for the murder. If they do, that murder case will be assigned to me because I have your older cases. And we try to get all the cases that a defendant has in front of one judge. Makes it easier to schedule, and then you're not getting these different rulings from different judges. So that murder case would come here. Mr. Tolles would be here with you to talk about the murder case. The reason why I said sideline is the murder charge is the most serious. You can get life for murder. And typically what happens is that the lawyers say, let's not worry. These other cases are serious. I don't mean to suggest that it's jaywalking. But typically what your lawyers would say is, let's just not worry about the armed robberies right now. Let's worry about the murder. You're not going anywhere until the murder is resolved. It doesn't have to work that way. You may decide, it sounds like you and Tolles had talked about it a little bit. You may decide to resolve the armed robberies, and you're free to do that. And if Mr. Shepard says it's time, Mr. Norris wants to enter a plea, we'll do that. But often what happens is that the lawyer says, let's just not worry about the armed robberies right now. The thing you really need to worry about is the murder. Because if you're found guilty of murder, the only sentence you can get is life. With armed robbery, they're not small sentences, but they can be a lot less than life.
They can also be thrown out too, right?
They can. It could be dismissed. It could be that the state says, we're not going to go forward anymore. We'll certainly argue these motions. If Mr. Shepard is successful in convincing me that I should throw out the evidence that was seized, it could be that the prosecutor says, if we can't share with the jury whatever the evidence is, then we dismiss the charges. So there are a lot of different options, and I'm not excluding any of them. What I'm letting you know is that typically, if someone has a case other than murder, and then they get a murder case that comes along, that other stuff just sort of gets pushed to the side, and we deal with the murder. But that's not a legal requirement. It's not a strategic requirement. If you and Mr. Shepard want to move forward with the armed robberies, we'll do it. There's still open cases, and it's business we can take care of.
I tell Mr. Shepard, can he please come by and see me?
Yes. Well, now whether he sees you or arranges a way to do it, but Mr. Shepard, Mr. Norris would like to connect with you in whatever means you've been connecting with folks at Rice Street, okay?
Will do.
Excellent.
And as soon as
So
we get
clear.
the paper discovery, we'll mail that to him also for not 927.
Yep. So we're clear. Ms. Hall, you're going to take a look when you are able to see what, I'll call it non-digital. You may have digitized it, but things like police reports, incident reports. Mr. Shepard is saying, I don't have any of that. Now, if you confirm that that's on the disk, and maybe Mr. Shepard just hasn't found it, you can tell him where to look. But otherwise, we need to get that to Mr. Shepard. He has until March 1 to file any particularized motions in 927. And then mid to late March, we will have a motions hearing date for Mr. Norris and his 2 armed robbery cases. And we'll do that regardless of what's going on with the murder. The state may not indict the murder. So we're not going to pause and ignore you or anything like that. I'm just letting you know that if they do, you and Mr. Tolles may decide, let's focus on that instead. Okay? So Mr. Shepard's going to make his best efforts to connect with you soon. I'll look for motions by March 1. We will see you again for these 2 cases sometime in March. Okay. All right. Ms. Hall, anything else in Mr. Norris's cases?
Nothing further from the state, Your Honor.
Mr. Shepard,
Nothing further from the defense, Your Honor.
thank you for dialing in.
Thank you, Sheriff.
My only matters, may I be excused?
You may.
Thank you.
All
Your
right,
Honor.
Mr. Norris, he will come see you soon, and I'm sure you'll be in touch with Tolles as well, all right? You're welcome.
Thank you. Have a good day.
No problem. Ms. Hall, my thought on Mr. Thompson is that we give Ms. Snyder about a week to connect with Mr. Thompson. He should be here. And according to Ms. Snyder, it's not typical for him to have missed court like this, but there is this weirdness of Ms. Snyder not being able to get into her office, get to her files, etc. And so my thought is we give Ms. Snyder until maybe next Wednesday to let us know what's going on. And if we don't hear anything by February 3rd, then I will sign a bench warrant for Mr. Thompson. We can clear that bench warrant by walking on into court someday with you, Ms. Snyder, with an explanation for what happened. And it sounds like it will be a logistical one because of your unfortunate move. But that said, he did get something in the mail. If he moved and didn't tell us, that's more on him than anyone else. Does that work? Okay. Ms. Hall, you okay with that?
I am okay with that, Your Honor.
Okay. All right. So let me just make notes here. All right, I think that's it. Mr. Daniels was not brought over. I think that's your client, Mr. Franklin? Correct. You'd wanted to, it was originally on for plea and arraignment, and you'd wanted to do bond. You have filed a bond motion, but then I was told someone didn't want him brought over.
That was myself.
Okay.
So I had a visit with him at the point that I filed the bond motion. I just came into practice of trying to do that now ahead of time. And after speaking with him, I saw some issues and I need to get an ex parte signed by the court at some point.
So we're gonna sit tight, no bond hearing today. Have you waived arraignment, or we're not even going that far because of what you want to have checked out? Okay. Is that something you can get to Ms. Nelson or me pretty soon?
Yeah, today.
Okay. Got it. Thank you. Then that gets us to Mr. Dewar. Did I pronounce that correctly?
He's present.
Great. Why don't you come on up? Is it Dewar or Dewar? Dewar. Come on up, Mr. Dewar. All right. So my notes say that this was on a status calendar of some sort in early November. And at that time, Mr. Franklin, you had asked for time to review the case and figure out where we're going. It's on for final plea. And I don't see anything that suggests since then you said, well, actually I'm missing all the discovery or this or that. So should we get what the offer is from Ms. Hall and go from there, or is there something different going on?
We can talk about the offer. It's kind of the update would be a status of negotiations, basically.
Okay.
We have been talking about a virtual resolution that involves a dead docket and completion of conditions. The conditions to this point would be a stay away from the complaining witness, Ms. Simone Lett, L-E-T-T, and she had concerns about whether Mr. Dewar had mental health issues, so an evaluation and any follow-up if deemed necessary. I wasn't able to have a real conversation with Mr. Dewar until this morning because his cell phone had been deserviced for a period of time.
That's who you were talking with earlier. Was okay. Great.
And in our conversation, one of the things that I think is particularly an issue, they had 2 children together. One of them very young. The youngest is 1. And so the stay away would be problematic for him because it would limit his ability to be a father. The state, of course, has concerns given the nature of the charges and Ms. Letts, from what I understand, her interest in a stay away. I'm trying to seek a legislature that makes the visitation of the children a more possible thing. And it doesn't appear we can identify a person who can act as an intermediary.
There's not a grandma who can be the handoff supervisor.
Right. So I'm trying to see if that is something that the state may be able to get around to, and if so, if that is something that Mr. Dewar would be agreeable to. The state had loosely before mentioned a probation sentence. We hadn't actually talked about that, but Mr. Dewar is here on a green card. So from my position, it's not anything that we can do if he wants to stay in the state. So we're still negotiating.
We could move this to a trial calendar, whatever that means these days, because it sounds like this is either going to be a trial if there's no meeting of the minds, or there will be something sorted out that would result in some type of diversionary disposition.
That's my read on the situation. Ms. Hall can comment as to if that's her understanding as well. It's a trial or it's a...
Ms. Hall, what are your thoughts about the Dewar case?
My thoughts are, well, as I told the defense attorney, or Mr. Franklin, the consideration of us doing a dead docket or virtual PTI was really contingent on him staying away from the victim. Everything circles around that. And so I need to make a call to her to see if I doubt that she changes her mind as far as the stay away, because that's something that she's watching via YouTube, but that is something that she really strongly wanted in our conversations.
Sure.
So I need to have a conversation with her and see if we can adjust that at all. And if not, then I'm left with the 2 options I've already presented to the defense counsel.
Okay. But as of now, the state's offer would be a plea to some term of probation, a condition of which would be to stay away from Ms. Lett and their children, I guess.
Well, no, not necessarily. Our current offer is the dead docket for a 2-year period with the conditions of the stay away and the mental evaluation, with any recommendations that came from that.
Okay.
I learned this morning that the defendant is an issue with the child care handoff situation. So now that puts me in a different situation. So the offer is still the dead docket. I just want to talk with the victim and see if we can adjust it a little bit. If not, I'll let the defense counsel know that. And then it may, our original offer was probation.
Okay.
Considering that the case was old and that they have still communicated in these 2 years and it hasn't been any other instances. Mm-hmm. And she didn't want to see him in prison. And then she, so that's how we ended up here. But I need to talk to her to see if we can end it there or if we have to go back to the probation.
Okay. No, it sounds like Ms. Lett is being very reasonable, but also cautious. And I get that.
Right.
Her request of the state, not that she controls it, is not this guy needs to be buried under the jail. He goes his way, I go my way. and he's just not around me. The complicating factor is the two kids. And I can understand why Mr. Dewar would want to be able to spend time with them. It does sound like you're close. So what I'll do is move this to a trial calendar. We may put it on a status calendar a couple months out just so we don't forget about it, because that will poke everyone a little bit. Because realistically, this wouldn't appear on a trial calendar right away. Mr. Dewar's not in custody, which is good. And we'd be focusing on people who are. We'll assume final plea has been taken care of. And the next formal stop would be a trial calendar, but we'll see if a status calendar in a couple months might bring everyone together. Does that work for you, Ms. Hall?
It does, Your Honor.
Mr. Franklin?
Yes, sir.
Okay. All right. So, Mr. Dewar, you have any questions for me? It sounds like if you and Ms. Lett are able to identify a third party, I don't know if it's someone's relative or this or that, who could help facilitate handing off supervision of the kids, you'd be real close to sorting this out. But I'll leave that to you and your lawyer, okay? All right, in the meantime, whatever the conditions of your bond are remain in place. So if you are not supposed to be going around Ms. Lett, you make sure you don't. If you do, that could result in some pretty messy charges following that, okay? If you've got any questions about it, make sure you talk to Mr. Franklin. Okay, thank you.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. And you are not doing Mr. Campbell, and you are not doing Ms. Cameron. I think those are colleagues of yours. So I think you're done.
Right.
All right.
Okay.
Thanks.
All right. Thank you.
All right. All right, that gets us to Ms. Boyce, who I haven't seen anywhere. I know we've got Ms. Allen. She's been on patiently the whole time, but she's number 8. So, Ms. Patel, what do we know about Ms. Boyce and her whereabouts?
I communicated with her yesterday, and I did expect her to log into Zoom. Normally she comes in court in person, so this would be her first time attempting to Zoom in. I can try to give her a call as soon as there's a pause in court to see where she is. But I did speak to her yesterday, so I don't have any reason to think that she would not have joined in on this call.
Okay. Well, why don't you go do that, because the next position is Mr. Franklin and Ms. Hodge and Ms. Allen. So we can do that. And then we're done until 11. I didn't realize that Ms. McCauley had been on the call, and she just left and said Ms. Hall can handle the Campbell case. But then, of course, we just let Ms. Hall go. But we'll work through that. That's not an issue for you all. So, Ms. Patel, you try to track down Ms. Boyce or get us an update, and we will talk about Ms. Allen's case right now, okay? Good morning, Ms. Hodge.
Good morning, Your Honor. How are you?
I'm well. Yourself?
I'm doing well.
We're going to pause 1 second. Mr. Franklin is talking to Mr. Dewar outside.
Okay.
Sorry to interrupt. We had to skip over Ms. Boyce, who is right now a no-show, but we've got Ms. Allen. Good morning, Ms. Allen.
Good morning.
So we're on for final plea. This, just like Mr. Dewar, was on that same calendar in early November just to do a check-in, and the decision or the request from the lawyers was, please put it on final plea in the new year. So here we are.
So, and just like Mr. Allen, we've had discussions about a dead docket situation. Unlike Mr. Allen, however, Ms. Hodge and I have been able to reach an agreement, and Ms. Allen has consented. She is currently enrolled in a program called Rekindle, Renew. What's the rest of it, Ms. Allen?
Reclaim.
Reclaim through the House of Chair located, I believe it's at City of Refuge off of Simpson Road. She's been there since October. The only detail that we had to work out before was what's the end date of her participation there. We talked about June, we talked about October. After speaking with Ms. Hodge yesterday, Ms. Hodge said it would be the October date, Ms. Allen. So you would have to stay there through October, which I don't think is any problem. She's done really well since she's been there.
Sure. No, I remember last time we met, it seems like a pretty healthy environment for her.
Yeah.
Okay.
So I've drafted the order of abeyance for it. I just need to send it over to Ms. Hodge and have her sign it. So we should have that to Ms. Nelson by the end of the day.
Okay. So what you're drafting has the terms and conditions that Ms. Allen will need to meet. The primary one would be to stick with the program through some date in October. She could still be on that, but she needs to stay at least that long.
Correct.
And should she do that, we would then presumably the state would move to null pros and we'd be done. Okay. Well, we'll look for that, and that'll give us the particular date to check in with everyone to see if Ms. Allen did what she needed to do. Ms. Hodge, anything you want to add? Any other details?
No, Your Honor, that's what we discussed.
Okay. Ms. Allen, do you have any questions about what's happening?
More so about juvenile court situations, because I feel like things before the incident took place have been ignored. I did try to write you a letter. I don't know if you received it. I sent it out in December. And I really just want to get my life back to normal and try to get my kid in my life. I do understand the pandemic is still going on. Courts are being delayed, but I've reached out several times. I made every attempt I could on my own understanding that I could to try to get it done through juvenile court, and I haven't gotten anything done. Last court session, Ms. Hart said that Jamil's dad wanted to co-parent. I haven't had any luck. And my case manager here is doing the best she can based on the information she has and how long she's known me. So that's really it. I think just more of a voice I think I should have.
When you say juvenile court, is that where the proceedings were that took you and your child apart, or what's the? I mean, you're too old to be in juvenile court. So what's the juvenile court?
No, my son. Any dealings with my son would be with juvenile court. But when I filed to, you actually signed an affidavit for me in June. I met you, and I got a court date for like November 10th. Mm-hmm. But being here, I didn't know I had a court date, and it was dismissed.
Okay.
So I haven't gotten anything else done.
Okay, I see. So you're trying to, and that's not through DFAX, it's through juvenile court.
DFAX has not answered the phone.
Okay.
Khadijah and I have called, and I've reached out for over a year and a half almost to try to co-parent, and I haven't been able to.
So your son is with his father?
From my understanding, yes.
Okay.
We don't communicate. We're not allowed to.
Okay. Well, these are all good.
The last conversation I had with the child's father, he is still with the father.
Okay. So, Ms. Allen, it's a great thing that you are working hard to reconnect with your son. And it sounds like you're going through the right channels, whether it would be DFAX or juvenile court. Mr. Franklin is not a family law lawyer, so that's not his area, but he may be able to steer you towards some resources. It also sounds like by working through your case manager there, you're heading in good directions. But I can hear the frustration in your voice that what more do I need to do? You're calling and you're not hearing back. So what I can tell you is it sounds like you're doing all the things you need to do to make these charges go away. And these charges going away will only help the steps you want to take to get your son back in your life. So that's good news. These charges hanging over your head are going to make it difficult for you to make a whole lot of progress with co-parenting and reuniting with your son. So you're certainly heading in the right direction. Do you have any other questions?
No.
Okay. Well, Mr. Franklin will be in touch with you. Is she going to need to sign as well, or you and Ms. Hodge? Okay. All right. then what I'll do is sign what I get from Mr. Franklin and Ms. Hodge. That's going to put your case on a dead docket, which will sure help you, because then if you are trying to connect with DFACS or juvenile court, you don't have open and active charges. They've been dead docketed. And if you keep doing the good work you've been doing, later on this year, they won't just be dead docketed, they'll be dismissed. They'll go away entirely. All right?
Okay.
All right. Ms. Hodge, anything else in Ms. Allen's case?
No, Your Honor, nothing from the state.
Okay, well, if you'll review what Mr. Franklin sends you, and if it meets with your approval, if you can get that to Ms. Nelson, we'll take care of it. All right?
Yes, Your Honor.
Thank you.
And Ms. Nelson, have Ms. Khadijah email me. We can schedule time to talk more about that other end of things. I know the last few times we talked, we've only talked about the case itself. So have Ms. Felder email me and see if we can arrange a time to let you talk me through the other half of stuff.
Okay.
Okay.
Thank you.
All right. Thanks, Ms. Allen.
Thank you.
Ms. Patel, do you have an update on Ms. Boyce?
Yes, Your Honor. She's having extreme difficulty with her phone. I called her a few times and it keeps dropping the call. So she has offered to come in person. She said she could get to court in 20 minutes. I told her I would leave it in Your Honor's discretion because I know that you have something on the calendar at 11. But ultimately, Ms. Hodge and I was not expecting for this case to resolve today.
Okay.
I can explain that a little further.
Yeah, well, it would be good to get Ms. Boyce in the mix for that. So why don't you have her come on down, and we'll pause whatever we're doing with Mr. Campbell. We need a prosecutor to do that anyway. And that's good. Whoop, Ms. Boyce is coming on right now. Look at that. Good morning, Ms. Boyce. Can you hear me?
Yes, I can hear you.
Great. We can hear you too, and some thumping noise.
I had to come outside because the house is like no service.
All right, well, as long as you can hear us, I'm going to let the lawyers do some talking, okay?
Okay.
Can you mute your phone for a sec?
Mute it. Okay.
Well, it's good for now. All right, so tell me, Ms. Patel, what's going on with Ms. Boyce's case?
Your Honor, I do expect this case to be that we resolve this case with a plea of sorts. The issue is that as part of the state's offer, the state is asking that Ms. Boyce complete some classes, I believe parenting and anger management classes. Ms. Boyce is currently homeless. She's employed part-time, but it's not consistent. And so we've been trying to find a way to get her classes for free. On top of that, this would be a first offender plea. She doesn't have criminal history. So my concern is signing her up for something that I know she would potentially fail at. Right now, we're trying to get her those services through DFACS. The issue has been that DFACS has not been picking up their phone. She has called them repeatedly. I think she indicated to me she's going to go there in person tomorrow to see if she shows up there in person, if she can sign up for the classes. And so we're simply asking for either that we reserve her final plea rights, but let the case move forward, or just a reset to see if we can get her in the classes so that I can at least have some sort of guarantees that she'll be able to do them and be in compliance with probation.
Ms. Hodge, that sounds reasonable to me. It sounds like Ms. Boyce is in a tough spot right now. Do you have any objection to preserving the final plea rights? I think what we do is flag this as a case that's ready for a trial calendar, but like we're doing with Mr. Dewar, not your case, we'll put it on a status calendar in a couple months to see, hey, if we had any success in stabilizing Ms. Boyce's housing situation, and should she be in a position to comply with the conditions of the plea.
No objection, Your Honor.
Okay. So, Ms. Patel, what I'll do is flag this for further notice. The trial calendar will preserve the final plea rights, but we'll also get everyone back in here in a couple months to see if we've had some positive developments.
Thank you, Your Honor.
You have a good phone number for Ms. Boyce. That's how you reached her. She's just having technical issues with her phone.
Yes, Your Honor, just technical issues with her.
Okay.
I believe.
All right, Ms. Boyce, if you can still hear me, do you have any questions?
No, sir.
Okay, well, I wish you good luck in trying to stabilize your situation, and you just stay in touch with Ms. Patel, okay?
Okay, thank you so much.
All right, thanks for dialing in.
All right.
All right, I think that is our first calendar for the day. I think that concludes your business, Ms. Hodge.
It does, Your Honor. Do you need me to contact Ms. Hall and ask her to dial back in at 11?
I guess if you don't mind doing that, I don't know if Ms. McCauley is going to be able to come back. She has to be with Judge Krause as well. The calendar wasn't till 11, so I guess why I didn't notice Ms. McCauley on the call. But yeah, we need to have a backup. So if you could have Ms. Hall ready to go by 11, although let me see, Ms. Snyder, you represent Mr. Campbell. Okay, do you need some time with him or what's the situation?
I spoke to him this morning. His answer changes every time I talk to him, so I guess we'll find out.
Then I guess if you could get Ms. Hall to rejoin us whenever she's ready, we could put it to Mr. Campbell now. His lawyer is sitting right here. So let's just try to get Ms. Hall back.
Will do, Your Honor.
Thank you.
I'll give her a call right now.
Sounds good.
Okay, thank you.
Yes, sir. Thanks.
Take care, everyone.
Good to see you.
And Your Honor, may I be excused?
Yes, ma'am. Thanks for dialing in.
Thank you, Judge.
I'll be right back. I gotta get my paperwork from the Hill plea.
No, it's not.
You know, we may not be able to start right away. I don't see Ms. Rolak right now, but it may be that there were folks who were going to be watching at 11. I don't want to skip that window. What had Ms. McCauley recommended for Mr. Campbell?
25 served 8.
Okay, that's what I have written down here. And then you had asked for 25 to serve 5? Okay, I just want to make sure my notes were accurate. Thank you. And that's what he was. Okay. And then he had a case to revoke as well. It looks like an old case with only a few months left, but we'd be able to close that out.
Yeah, it's been in continuous custody since 2019.
I didn't even know. I think I merged you guys. No, Cassie merged them. Oh, yeah. Okay.
Hi, Judge.
Hello?
It's 88 Hall.
Oh, hey.
Hi.
So thanks for rejoining. It dawned on me after Ms. Hodge was reaching out to you. We need to find out from Ms. Rolock, who I don't see on the call, if there are going to be victims who were assuming we'd start at 11, which is what the calendar says.
Yes, Your Honor. Ms. Rolick had another appointment this morning, so she won't be available until 11.
Okay,
So
So-
I'll come back at 11.
yeah, let's plan on doing nothing on Campbell until 11.
Okay.
So if you can track down Ms. McCauley and she'll be back at 11, that's great. Otherwise, you should be here at 11. We'll see Ms. Rolack and she'll have folks plugged in.
Okay.
Hey there, Ms. Crawford. So you're welcome to sign off or just
Okay.
have your screen go dark, but we will reconvene at 11, which is in about 15 minutes, a little bit more than
Okay.
15 minutes. All right. Thank you.
You're welcome.
Sorry, Ms. Snyder. I thought we'd get you out of here early, but it's not like you have an office to go back to anyway. Yeah. All right. So I'll come back out here a little bit before 11. We'll get you fine out here and be ready to go. And then our only other matter after that is not till 1. And I don't know if that person's clearly not in custody. I don't know if she's walking in or if it's Zoom. It's a white collar case from the DA's office. Yep.
I think that's at 2, Judge.
Oh, it says 2? 2. Is that 2? No, I'm not moving it. It's whatever time it says.
Okay.
2 o'clock. Thank you, Ms. Nelson. Is it 2 o'clock? Oh, that's right, because I have a meeting at 1. I'll be out here for a Zoom meeting. Okay, great. So I'll come back out in about 15 minutes. I don't know. I don't know if people are coming in or not. I'll be out here and we'll have Mr. Forte here. Yeah, that's only that room. No, like. No. No, I got, friend of mine doing, yeah. From my home, so. He's tired, he's going. Go back. Go back.
Okay. On your way,
Okay.
probably in,
Mine is oil.
whatever. Stick it on the front wheel.
Just I can see through you standing over there. Okay. That's fine. Hey, good afternoon.
Let's see who we've got online. Ms. Hall, Ms. Rolak. Okay. I think we're good. You ready for your client?
Mr. Thompson came.
Oh. All right.
He on public transportation logo.
Got it. Then I guess his case will be on hold while we work through Mr. Norris's, unless you wanted to move on a different track.
No, I think that's fine. We submitted what we believe is story evidence. The state is supposed to be getting me their expert's report. I still haven't gotten it. She did reach out to Ms. McCauley and check this stuff about where that report is.
This was someone analyzing a cell phone and, okay, all right. Hey there, Ms. Hall, real briefly on Mr. Thompson who showed up. Any update on the expert report?
Yes, Your Honor. I spoke with Investigator Sluss last night, and he hadn't gotten around to it. He's on the homicide over at APD, so he explained all that to me. But he did say if I can give him until Friday or early Monday, he'll have that report to me. He did tell me what the report contains, so I do at least have that information.
Okay.
It's gonna lead me to a different type of investigation from the state, but we do have his report, we will have his report early next week.
Okay, well, you and Ms. Snyder keep working on it. We're gonna have Mr. Thompson track Mr. Norris for a little while longer. I'll tell you, if Mr. Norris's murder gets indicted, then I think his armed robberies will be sidelined, but we will want to press forward with Mr. Thompson. I don't want him sort of twisting in the wind out there if we can resolve it. But for now, you've got time. Thank Investigator Sluss for taking time out of his day to analyze that stuff. And then I guess you can let Ms. Snyder know, and if we can get Mr. Thompson in here sooner, let's do that. Otherwise, he'll just track Mr. Norris. Okay? I'll let you explain that to Mr. Thompson, but let's bring Mr. Campbell out. Hello, Ms. McCauley.
You're on mute, Lauren.
I'm sorry. Hi, I was shouting at you. Hello.
All right. Are you ready, Mr. Forte? We are together again in 19 SC 166417. It's State versus Campbell. Hello, Mr. Campbell. I'm okay. How are you doing today? Yeah, I know you're in a tough spot, but you are back with your lawyer, Ms. Snyder. You had asked for some extra time to think through where we were in this process, and I want the record to reflect where we are. A few weeks ago, it may be over a month now, we had Mr. Campbell here with Mr. Hill, and they both were entering pleas. They had the plea colloquy with Ms. McCauley, who is connected remotely here today. Mr. Hill went all the way through with his plea. He was sentenced. He is doing what he needs to do now. Mr. Campbell, when he learned that I was inclined to go with the state's recommendation rather than his lawyer, Ms. Snyder's recommendation, said I'd like some time to think about it, which makes sense. It's Mr. Campbell's time, not anyone else's. Mr. Campbell, have you had time to think about what you want to do in this case?
Yes, sir. Can you speak up to the microphone?
Yeah, you just roll on in there a little bit. Great.
Yes, sir.
So, so no one's left trying to remember. The state had recommended a term of 25 years to serve 8 with a balance on probation. And this is in connection with a whole number of burglaries and entering autos. Ms. McCauley made a very, very detailed record. It is your record, Mr. Campbell, in the same way that it's Mr. Hill's record, so we don't need to repeat all of it today. But after I heard victim impact statements and everything about what you were allegedly involved with, along with Mr. Hill. I felt that the 25 to serve 8 with the balance probated was the more appropriate sentence. I think I explained that I could understand the state seeking even more than that, but what they felt was appropriate in light of everything that was involved was that recommendation, and I was going to go with that, which was a few years more than what you had asked for through your lawyer. And I need you to let me know, Mr. Campbell, if that's what you want to do today, or if instead you'd rather have your case go to trial. You have a right to trial. We can bring in all these victims and get all the evidence that Ms. McCauley talked about in front of a jury and see what the jury says. They may say, state's got the wrong guy, or they haven't proven their case. And then you dodge a bigger bullet. But I suspect if the jury found you guilty at the end of the trial, that Ms. McCauley or Ms. Hall, whoever prosecuted the case, would be asking for a bit more time than they are now. So you got a few unknowns out there. The one certainty you've got is that if you want to go forward, now you know what sentence I plan to impose. And last thing, and I'll hear from you, you have an old case that it sounds like may have just a few months left on probation, and we'd revoke that and run it concurrently, so that would be out of your way. Any questions about anything I just said?
No, not about anything you said.
Okay, so tell me what you want to do. Do you want to finalize this today, or as I promised you before, do you want to withdraw everything you've done and we'll move your case to a trial calendar?
Ready to get it over, but I'm confused. I don't. Been out 2 years. I haven't seen those. Like I'm just charged, and I haven't talked to her like really. I talked to her 1 or 2 times. Like, I don't know really what the case is about. I haven't seen no discovery package or nothing. It's been
So, I think you know what the case is about. We spent a lot of time together talking about what the case was about and all these burglaries and things that were taken from house after house, Peachtree Battle here, there, whatever. We heard about how Ms. Phillips maybe was selling this stuff. So I think you know what it's about, and it sounds like jail calls would show us that you know pretty much what it's about. But what you need to let me know today is not, gosh, I'm frustrated, I want more time, or this or that. Is I want to go forward, or I don't want to go forward. And either one's fine with me. I'm not going to have heartburn in either direction. You're going to be sitting tight till we can get you a trial, and I can get bond. But you're entitled to a trial, and if that's what you think is the best way to push through this, then that's what you should do. That's what I need you to let me know today. You've had time to talk with Ms. Snyder. If there was something you were missing, like, hey, I want to see, I don't know if you gave a statement to the police, but let's say you did. I want to see my statement to the police again, and she can make that available to you. And if it really hinges on something like that, then that's what you ought to do. But my sense is, you know what's out there, and you just need to decide, am I going to go with what has been explained to me would be the outcome, or do I want to try my chances at a trial and see what a jury would do? Because you've got that right. No one's going to take that from you.
That's what I'm saying. I want to get it over, but I don't know what's in my bed. Like I haven't, like I just said, I supposed to been discussing it with her, but only thing we discussed is, do you want to take time? Like I said, I ain't got no discovery package and nothing to go over the case myself to know if I do want to go to trial or nothing.
So, Ms. Snyder, tell me what's going on with Mr. Campbell and discovery.
I sent him discovery twice, once when he was at Rice Street, and then once after I realized he had been sent to the state system, I sent it to the program. So this is the first time I've ever been told that he's never got discovery.
Okay, and you've had a chance to talk with Mr. Campbell since we last met. And he didn't ask you then, hey, you know, I don't even know what I'm pleading to. I don't know what this case is about. Okay, that's the first time he brought it up. Okay. So, Mr. Campbell, you are entitled to, I don't want you guys to duke it out right here. If you would prefer to spend time with discovery and see what you can do after you've looked at that, you certainly should do that. Today, in the next couple minutes, is when you can move forward with the state recommending 25 to serve 8. If you don't want to do that, I will honor that request and we will see you at another time, but I suspect that the state won't be recommending the same thing. Most of all, I will not enforce that offer. That offer was already extended once because you said you wanted some time to think about it. We've given you time to think about it. And here we are, and you're still thinking about it. I'm not rushing anything other than to tell you that if you're still not ready, then maybe you shouldn't go forward, but then the state's going to withdraw that offer. And if you decide a month from now, hey, I do not want to trial, I want to work it out, and Ms. McCauley or Ms. Hall or someone comes in here and says, it's 25 to do 15, you don't get to say, no, I want that 8 back. You can say it, but it's not going to get you anything. So this is the cutoff point for that. But that's it. I mean, otherwise, you still have, if you want to get ready for trial, you can spend more time with discovery.
I mean, my whole point of thinking about it was so I can go over the case. All I'm saying is I never went over the case. I told her I didn't have a discovery a while ago. She said she was going to get me one. The first time I talked to her on the phone ever, within 2 years, that was in December, the first time I ever talked to her on the phone, 2 years. I told her that she said she was going to try to get one to me. Never got it.
Well, it sounds like
on my phone record, since y'all say they get out of my phone record, it's on my phone record. I told her this. Okay. She said, I never said that. I have said that.
So it sounds like then you don't think it's a good idea to go forward today, and I respect that. And you don't need to go forward.
Idea for, I don't want to be. I need a new representative. That's what I think.
Well, you and Ms. Snyder can work through that between now and whenever we can get you in here for trial. But what I'm going to find is that Mr. Campbell does not want to go forward with the plea, so it is withdrawn. As I told you before, Mr. Campbell, this is nothing that can be used against you. So when you do go to trial, the state doesn't get to tell the jury, well, actually, he just about pled, but then he changed his mind. This was all part of negotiations. Negotiations are not things that get shared with the jury. Okay?
Yeah, I ain't gonna say I changed my mind. Just I never went over the case. Like the time that I was asking for to go over the case, I never went over the case.
So, Mr. Campbell, the time for you to share that with me would have been when we were together last, and you heard Ms. McCauley in great detail share with me what this case was about. And you said, I'm not ready to commit to that then. That would have been the time to say, because, Judge, I never seen any discovery in this case. But
she said she was going to get with me, and she said she was going to send it, but I never received it.
Okay. Well, like I said, you and Ms. Snyder can work through that. And if the way that sorts out is that you want to represent yourself or you think you ought to have a different lawyer, we can work through that. There's a process for working through it. But we're going to not go forward today with the plea. And that offer is withdrawn, and I will have Ms. Nelson figure out when we can get your case on the trial calendar. By then, maybe we'll have caught up with Ms. Phillips, and she can go to trial with you. You guys will be able to connect that way, okay? Thank you, Ms. Snyder. Appreciate it. Ms. McCauley, thank you for dialing in.
See you later.
All right, take care. Thank you, Ms. Hall, for the return visit.
You're welcome. Bye.
Bye-bye. Ms. Nelson, are we using this feed for the 2 o'clock? Should I leave the meeting open?
Yes, sir, we are.
Okay, I'll do that. I'll turn off the video. And do you know what's happening at 2? I'm remembering email traffic with people saying like, oh, we're close to working it out. But it says motions hearing. Have you gotten any?
Well, it was supposed to be the motion for restitution is what we actually were scheduled. And then I think the one of the attorneys thought that they would enter a plea. She was wanting to get that rescheduled, and I I did not reschedule it since it's already published calendar. So hopefully either a restitution hearing or a plea.
Let me look at the docket real quickly, and then we can figure that out. Okay, it's just odd. You usually don't have restitution hearing until there's been a plea. But I guess they
Yeah,
wanted to.
Right, I do believe she had filed a motion for restitution
Hold on.
hearing, and then I calendared it.
Okay,
Yeah,
it does. I see that
changed.
motion for a restitution hearing. That's sort of cart before horse. Because there's no restitution owed if you haven't pled, but that's what was coming.
And so I think they were saying they wouldn't need the restitution hearing and that they wanted to enter a plea, but wanted another date to enter the plea. And
Okay.
so that was it.
Got it. Thank you. Well, we'll be here at 2 o'clock, see what happens.
All right, thank you.
Thanks. I cannot. You're right. But I also don't need it. I'll just have to do it with, I just won't be on video. I'll do it from my office. That'll be the easier way to do it.
Stop meeting and then we dial back in later.
Yeah, but then, I mean, we have to shut all this down or the YouTube would be broadcasting. This is this accountability court judges meeting and all this.
Well,
stuff.
Judge, I'm sorry, I don't mean to interrupt, but if you want to put it back as me, the host, then I can restart the meeting.
Could we do, is that okay? Is that hard to do or does that mean IT has to come down here? Okay. All right. Yeah. So I'm going to make you the host then, please.
And I'll just keep the meeting up.
Great.